If you can hear me. Apologies for the slightly delayed start. I was expecting Simon Wong of Elahan to be here to introduce us, but I think he's been detained. So it's slightly unusual turn of events, but I will introduce myself and then start on the topic. Thank you very much all for your patience, given that it is a few minutes past our scheduled start time. My name is Matthew McGhee, and I'm a commercial barrister in London at 20 Ethics. I'm very pleased to be invited again to speak to the institution. I was previously asked to speak to you a few years ago, and I'm particularly pleased to be back for the second time. My practice is fairly broad across a range of commercial work, both in court and also in ad hoc and institutional arbitration. I'm going to be speaking to you today about a topic which has come up on a number of occasions in different contexts in different industries, and it is what is, I suppose, a regrettable hazard of doing business in the modern world. That hazard is the relative frequency with which business-related emails can be intercepted by a wrongdoer, who then uses the fact of that interception as a means by which to divert money away from their intended recipient to the fraudster's own interest. Typically, what they do is they will intercept invoices that are passing from one company to another and simply change the bank details to be those of their own interest. As a result, the fraudster will intercept a genuine payment from the paying company and cause the paying company to send those sums unwittingly to the fraudster instead of the intended recipient. What then invariably happens is that sometime further down the line, there is a fallout between the paying party and the intended recipient party about who is going to bear the loss of this particular fraud. From the paying party's perspective, they are understandably reluctant to pay the price twice. From their point of view, they have already done so. But from the recipient's side of matters, someone else has come and stepped in and taken money that was intended for them, but it was never received by them, and therefore they should be entitled to the sum they are contractually due. Now, as I have already alluded to, this particular issue is one that affects a huge host of industries and also a huge array of entities, from very small and relatively unsophisticated operations through to large multinationals, dealing with very large payments indeed. It's typically arising in these sorts of corporate contexts, but again, is not limited to that. I've certainly seen cases where it is involving individuals and their own money, not just corporate funds. So in today's lecture, what I'm intending to do is to explore which of these two ostensibly innocent parties, the sending party, the paying party, or the intended recipient, is likely to end up bearing the loss arising in this particular scenario. Now, I'm going to do so through the prism of English law and English law as it stands. It is something of a developing area. It's also an area which I know has been developing in other jurisdictions. Nowhere, so far as I'm aware, has landed on a firm answer as to how this is all to be addressed. And therefore, I hope that although I'm providing you this input from an English law perspective, it is still going to be of interest and relevance to you, even if you're dealing with arbitrations that do not have English law as their governing law. Certainly, English law does not have all of the answers yet, and I will explore has perhaps made a partial misstep. So our experience on this side of the fence might be informative for how you want to take matters forwards in your own jurisdictions. Now, I've given the title of this talk, I've given this talk the title of Ghost in the Machine. That term is borrowed from philosophy, where there's a bit of debate as to the degree of separateness between mind and body. And one school of thought is that the mind is the ghost, which gives life to the machine which it inhabits, that being the body. The two are separate but complementary. Now, I'm going to be using that term in two ways in the course of this talk. The first and the more prosaic is going to be referring to the ghost as being the fraudster who is operating quietly, undetected within the machinery, which is that of an email server, the company's emails. That's going to be where I'm starting, but where I'm going to end is talking about it in a separate way when we start to move on to the advancing frontiers in artificial intelligence. Now, towards the end of my talk, I'm going to explore how the current developments that we are seeing today are also developing the ability of fraudsters to engage in this sort of wrongdoing, and also what that means for our understanding of artificial intelligence systems and how they might perhaps be understood in the future going forwards, whether they are their own ghost, their own personality that we need to recognize. So having started with that introduction, I first want to give, I suppose, a quick primer as to what I've termed the fraudster's toolkit. Now, by that, I mean the ways in which the fraudster will send fraudulent payment instructions to the paying party. A frequent situation, and probably the most basic situation, is a confusingly similar email address or a homoglyph. Now, that is where the wrongdoer will create an email address that superficially looks similar to a genuine email address, which belongs to the party which is entitled to payment. So what the wrongdoer will do is to create a new email address that looks similar, send it to the paying party, and hope that the paying party doesn't notice the slight difference, and perhaps merely one single character in the email address being changed. And what I've done on this slide is to give an example of a fictitious genuine email address, and then 3 changes that might or might not be noticeable. Now, the first and most obvious is within Ivan, changing it to Ivon, changing the A for an O, and this is to the email prefix, the part coming before the @ sign. It's relatively obvious in this situation. It's a relatively short name, but if the prefix was longer, it's easy to see how a simple change like this could be overlooked. Another change that I have made is to the first level domain, which is at the very end of the email address, changing .com to .co. Again, perhaps a relatively easy one to spot. The third change, which is perhaps the most difficult to spot, and I've certainly seen it come up frequently, is where the I in shipco has been changed. This is the second level domain, the bit coming between the @ sign and the final .com or .co.uk, as the case might be. Now, what's happened here is that I have switched out the letter I for a standard character that closely resembles the letter I, but isn't actually an I at all. Now, what I'm showing here now in red is the sort of underlying coding. So there's a whole series of characters within the Unicode system. They are standard characters that are recognized on an array of international systems. But some of them are what I might term non-standard characters, not conventional letters or numbers that are typically used. Now, in some systems, those aren't rendered as they ought to be, the digit that appears to be an I, and therefore they're rendered in this type of coding, which you can see the XN -- type is much more obviously an error. No one is going to be confused by that. But in many email systems, instead of that coding, what will be shown is essentially the I without the dot on it. So this is the sort of change which is commonly done and is commonly overlooked by people working in the ordinary course of business and not keeping an eye out at all times for the possibility of this sort of fraud. So that's the first and most common way in which these attacks happen. The second is something which I have termed spoofing and is distinct from this first confusingly similar email address situation. Spoofing is where the wrongdoer sends an email address from email address A, but it is sent in such a way that the recipient sees it in their inbox as coming from email account B. So the fraudster would be able to send an email from ivan@gmail.com, but when it landed in somebody's inbox, it would display as being from ivan@shipco.com, applying my example. Now, the reason for this is a sort of historic one as to how email protocols were developed over time. And the very brief potted version is that the sender of an email can choose what appears in the header of an email. And there is no technical requirement for the sender address in the header to match the sender address that is actually used to send the email. So this is a relatively low-tech way of making a fake email appear genuine. It is fortunately a relatively easy one to check, because if the recipient of this email clicks reply, then the email will show the genuine address to which the reply is to be directed. So that would be, again, in my example, ivan@gmail.com. So that would allow the fraud to be detected, but the fraud relies in this instance on the recipient just accepting what they see in Outlook or their email program, and not double checking that when they click reply, the reply to address is indeed the one that they were expecting to see. Particularly, this is particularly effective if this spoofing is used in combination with the confusingly similar email address, because then even if somebody were to look when they click reply, they would see a confusingly similar email address, and it is human nature that we see what we expect to see, and therefore the fraud could be overlooked. Now, both of these scenarios are solely dependent on what the fraudster is doing and what the fraudster is setting up from their side of the offence. There is no need for them to have compromised anybody's email systems to perpetrate this part of the fraud. However, the third way in which these attacks happen is the one that I'm going to dwell on today, because it's the most interesting in many ways. And that is where the fraudster hasn't just created an artificially similar email account, but they've compromised the actual email account. Now, I've just received a message that PowerPoints, about the PowerPoints. Yes, they will be available afterwards. I apologize if they're not clear enough on your screen. What I'll do is I'll change the view. So hopefully that is going to be rather easier to view. Please do let me know if there are any issues with visibility. I'm keeping an eye on questions that arise during the course of the chat. So do put things into the chat or into the Q&A box if you'd like me to address them as I go past. I'm glad that seems to be sorted. So I'm now going to be moving on to the more sophisticated form of fraud, which is where an individual has compromised the actual email account of the party who is entitled to payment. So what is instead happening is that an email is coming genuinely from the counterparty to the paying party saying, please pay this bank account. And there is nothing that the counterparty can do on the face of that email alone to identify that it has come from a fraudster rather than from their genuine counterparty. Now, the effect of this can be to lead to an instinctive commercial view that this sort of situation must be treated differently. In this case, clearly something has gone wrong on the recipient's side. Their emails have been compromised. And so one might think that they should be paying in this situation, whereas in the confusingly similar email address situation or the spoofing email address situation, it should be the paying party who pays again because they were the ones at fault. Now, to try and work through some of these issues, I've put together a brief case study just to essentially explore how this might operate as I go through the talk today. Very briefly explaining what I'm seeking to show on this slide is, I should say, all entirely fictitious. So two companies, Pollux as seller and Sirius as buyer, enter into a contract of sale for particular goods. They are both represented by their directors. Arno is the director of Pollux, the seller, and Catherine is the director of Sirius, the buyer. And the contract provides that Sirius shall pay the contract price to Pollux, but doesn't set out what the bank details should be. After the contract has been concluded, Arno then sends an email to Catherine introducing Bethan, who holds a finance function within Pollux. So it's going to be Bethan who is going to be sending invoices to Sirius under the contract. As is very commonly the case, the invoices are going to be sent via email, and some days after the contract is entered into, Sirius receives an email from Bethan's email address attaching a PDF invoice. It refers to the contract and requests payment to a particular bank account. I've given some examples as to what the bank account details might be, solely on the basis that these details will be entirely unremarkable if the seller was doing business in the UK. This is all perfectly conventional. This happens very frequently in business, even without the intervention of fraudsters. And what happens next is that Sirius pays the contract price. The difficulty that then arises in our case is what happens when it later transpires that Bethan's email account has been compromised by a fraudster and the invoice was sent by the fraudster, not by Bethan. It's in this situation now where Pollux, the seller, is demanding that the purchase price be paid. From the buyer's point of view, as I described earlier, they consider that they have already paid in accordance with instructions received from Bethan, or at least from her email account, and that this is all of the seller's problem. So the question for us is then, which one of them is right? Which of these two innocent parties is going to bear the loss from this particular fraud? The first port of call in trying to work out the answer to this is unsurprisingly what the contract says. The contract creates the debt that Sirius must meet, and the contract will provide for how that debt is to be satisfied. Generally, the contract will require payment in cash to the seller, and that has been held in an English law of K&A to require that the seller be given unconditional and unfettered rights to the immediate use of funds. What that is understood to mean, or at least my understanding of the law as it stands, is that it is sufficient if the money gets to the correct bank with clear instructions that that money is to be credited to the payee's account. Now, the context in K&A, there was a fraud, but coincidentally, the fraudster had diverted the money to be paid to the fraudster's bank account, which was held with the same bank as the genuine bank account, the seller's bank account. So in that case, the buyer tried to run the somewhat adventurous argument that the contract only provided that payment had to be made to the seller's bank, and that this had in fact been satisfied on that case because the correct bank had been paid, it was just the incorrect bank account. The court had little hesitation in construing the contract and saying that is not good enough here. Payment must be made, and it must be at least complete with instructions to credit the correct account. So that is clearly the starting position that's going to apply in most situations. But I say that with one caveat, that if the contract provides for payments to be made in a particular way, then payment by that particular way will satisfy the debt, even if the money is diverted along the way. There's a somewhat historic case I've referred to on the slide of Norman and Ricketts, where the contract, as it was construed, required payment to be made by posting a check to the seller. Now, the buyer did post the check to the correct address, but it was stolen in transit. And the court held that all that the buyer was required to do was to post the correct check. And after that, their debt was satisfied. It didn't matter if it was never actually received by the seller. So in our example, it's possible that the contract between Pollux and Sirius only required the buyer to make payment in accordance with directions received from a particular email address. Now, if that was the correct construction of the contract, then compliance with the fraudulent instructions would be enough to discharge the debt, even though Pollux, the seller, never received the money. that is simply a feature of the way in which the contract was set up. So that's satisfying the debt under the contract. A further way in which a debt can be satisfied generally is if payment is made to or at the direction of an agent for the creditor. Now, I'll be picking this point back up later, but if the payment by Sirius, the buyer, was at the direction of the seller's agent, then it satisfies the debt again, even if it was never actually received by the seller themselves. But before I get on to that question about the agency aspect, I want to deal with a different situation which has been explored a little bit in England. And this is where I indicated earlier there's perhaps a bit of a misstep on the part of the courts, or certainly the point has not been explored to its fullest. And that is the extent of what I've called a duty to secure, whether there is some sort of duty on individuals dealing over email to ensure that they are dealing with adequate levels of security on their email accounts. So if you work with me on the presumption at the moment that the contractual requirements for paying the debt have not been satisfied, we therefore have a buyer, Sirius, who is faced with a situation where they have paid at the instruction of an email received from a genuine account. It's not discharged the debt, and they are faced with having to pay the contract price again. And they feel somewhat understandably that it's unfair for them, the buyer, to bear responsibility for the loss, given that it was the seller whose email account was compromised. So naturally, the first thing that should be done is to comb through the actual contract itself to see if there are any express terms in the contract dealing with cybersecurity, or something that can be latched onto as a way to try and express this a grievance, essentially, that Sirius feels. However, my experience of disputes around these sorts of areas is that it is almost unheard of for there to be anything in contracts which expressly deal with matters such as cybersecurity. So we're a long way off these sorts of things being dealt with as standard under contracts. And therefore, the parties are having to look a little bit more creatively at how to deal with it. And one way in which this has been done is through the use of implied terms, or the attempted use of implied terms. The first case I've got on the slide is called Sell Your Car With Us and Serene. And in that case, a company sold a car on behalf of an individual, and the individual was then liable to pay a commission. But the fraudster intercepted the emails and instructed the individual to pay the commission to a different account. There was an attempt by the individual to telephone the company and confirm the change, but there was a failure to make that telephone connection. The phone call never took place. And what the fraudster then did is they realized that a failed telephone call had taken place. So they then themselves made a phone call to the individual and essentially confirmed over the phone what they, the fraudster, had already written by email. And we'll come back to verification procedures later. But in this case, what was argued was that there was an implied term in the contract that the company would take reasonable care over the security of its email communications. Unfortunately for parties in the buyer's type scenario here, the High Court dismissed that argument as a matter of law without proceeding to trial. Based on established authority as to the ways in which terms can be implied, the judge in Serene reasoned that it was not necessary to give business efficacy to the contract, and correctly said it's irrelevant that an implied term of this sort might have improved the contract or might have been a fair and reasonable term to read in. The question is strictly one of necessity. Does it have to be there in order for the contract to make sense? Now, there's been surprisingly little pushback against this decision, which is authoritative, it is precedent, but it is one decision on one set of facts, and there is certainly room to distinguish it either as a matter of law or on the particular facts of that case. And I have seen reference to a suggestion that analogies could be drawn with law in other areas where similar duties have been held to exist in existing contracts. Now, on the slide, there's a case which is called Macmillan, and that case concerned a banker and their customer, and it was held that the customer owed a duty to the bank to take reasonable care to guard against forgery. Now, what happened there was the customer had written out a check, but had written it out in such a way that it could have been easily altered by a third-party actor. And then ultimately what did happen is that a third party did amend the check in such a way that they drew more money than was initially authorized and absconded with the difference. What was held in that case was that there was a duty on the customer to guard against this sort of wrongdoing. So what could be said in our context, the email context, was that if you are engaging in business in a particular way, you do have this reasonable duty to take reasonable care to guard against forgery that is going to interfere with business in this particular predictable manner. So that's certainly an argument which wasn't run in Serene, as far as I can see, but it's one that could be run. There was a second argument in Serene which was slightly different, and that was essentially running a pre-contractual misrepresentation case. This also was dismissed without trial. The judge said that simply that there was no pre-contractual representation as to the security of email accounts, and that even if there was such a representation made, there was no reliance on that representation in entering into the contract. So on that basis, the claim failed either way in which it was ran. The only other case in which these sorts of arguments have been advanced is an unreported decision in Rijksmuseum Twente, where similar setup in some ways. There was a claim, again, between creditor and debtor, but this time between an art museum and an art dealer over the sale of a painting. And what happened there was that the museum was buying the painting and a fraudster diverted the purchase price away from the art dealer and instead caused the museum to pay the fraudster's own interest. For our purposes, there are two arguments which the museum attempted to run. The first was, again, to revive the implied term argument and to say that there was an implied duty on the part of the dealer to ensure that their email account was secure. But the judgment records that this argument was abandoned even before the end of the hearing in the face of remarks from the judge, who took a very similar approach to Serene. So that is starting to add weight against the Macmillan type argument. But as I say, the Macmillan argument has not been squarely addressed before the courts yet, so it is still live. It is still something that could be addressed in the future. In the Rijksmuseum case, the other way in which the case was advanced was a duty of care in tort, so entirely separately from the contract. And in that case, it was suggested that rather than there being an implied duty within the contract, there was actually a duty of care owed as a matter of general negligence law to guard against loss arising from this sort of wrongdoing. What was fatal to that way of expressing the case was that this is essentially a duty owed by one party, here the art dealer, to anybody in the world it might be engaging with to guard them against pure economic loss. And there are particularly high thresholds for getting that sort of duty over the line. And that threshold was just not passed on the facts of the case. So what I would draw from this decision is that the tortious duty is going to be much harder to establish than the contractual duty. If you're not getting it through on the contractual grounds, it's going to be very difficult to make progress on tortious grounds. So there is a array of possibility for the buyer, Sirius, in these sorts of cases, but it's going to be a difficult argument against existing authority before they can get there. So if that particular duty to secure is not available, what else is or might be available? Now, what I have posed here is a possible solution under the law of agency. And this is picking up on my earlier comment that payment at the direction of an agent will discharge debt. So if we can say that the buyer in my case study has paid in accordance with directions from an agent, then the debt is discharged even though the seller never received the money. Now, the difficulty here is going to be establishing ostensible agency on the part of a particular person. And the reason why I say that, and don't even consider the possibility of actual agency, is because it is very important to distinguish between the person who operates an email account and the email account itself. The email account is not a legal person. It cannot be a legal person. And so the email account itself is not capable of acting as an agent. So in running the agency type argument, you're not saying that the email account has agency. You're having to say that the fraudster, when they are using the email account, is acting as the apparent agent of the seller. Plainly, they're not going to be acting as the actual agent of the seller because they are, by the nature of these things, a third party who is coming into the relationship. So you're not going to get there on actual agency, and instead we have to look a little bit more creatively to establish ostensible agency. Now, that sort of analysis on whether the email account has or has not got agency, perhaps surprisingly, hasn't been addressed as a matter of clear authority in England. There is a single county court case which has touched on this, that J. Brazil Road Contractors. But more recently, the same analysis has been implicitly referred to with approval in a High Court case of M&S Restorations. So it strikes me that that much is pretty settled. It's going to be the apparent or ostensible agency, which is the more difficult thing to consider. Now, this is going to be a slight venture into the unknown because there aren't any clear cases dealing with this. But the principal issue that the buyer is going to have to identify is what representation was made by the seller that whoever is operating this email account does have agency on the part of the seller to give payment instructions. Now, my answer to this is on the slightly old authority of Barrett and Deere, which is now nearly 200 years old, plainly predates emails. But in that case, a person was found in the counting house of the seller, essentially within an accounts function. And because of where they were within the seller's business premises, that person appeared to be entrusted with the seller's business and dealing with the seller's finances. On that basis, the court held that this person did have ostensible authority to receive payment on behalf of the seller. And this was on the basis that anybody coming to the seller's premises and dealing with the seller was entitled to presume that the seller was exercising control over certain areas within their business premises. Applying that to the context we're currently thinking about with emails, I would draw the analogy as follows and say that just as a buyer who is entitled to presume that a seller has control over certain physical areas of their premises, a buyer is also entitled to presume that a seller has control over their own domain and email server. And therefore, just as in the Barrett case, somebody dealing with an individual in a restricted area of the physical premises was held to have ostensible authority, so too can somebody who is dealing, somebody who is in a restricted area of the digital space be held to have ostensible authority. So this strikes me as a way of trying to draw the balance between putting all of the responsibility on the buyer or all of the responsibility on the seller, because here there is a slightly more careful question about what sort of control do we require of individuals, what sort of control must they exercise over their emails. And it is only when we can establish some sort of fault in that level of control that we can say, because of that fault, the fraudster was able to perpetrate this fraud. And because of this situation, there is therefore going to be ostensible agency on the part of the fraudster to act on behalf of the seller. So it's an argument that needs to be deployed carefully, and there does have to be some nuance, because it cannot be as simple and straightforward as saying, if somebody is within a particular area, then without more, they must have ostensible authority. There's got to be some factor which allows essentially fault to be attributed to the presumed principal, and that can allow the agency argument to have some legs. And this is an argument that, as I said, is drawing on some quite historic cases. It has not been tested in the English courts yet. There is one case from earlier this year, which I put on the slide, called Logix and Siam. In that case, the argument was advanced, it was put before the court, but because of the way certain other issues were determined, this argument didn't actually need to be resolved. So it is still essentially a live question that is out there, and at some point somebody will need to grapple with it. If the argument can succeed and ostensible agency can be established, then that would allow for the discharge of the debt. So if we return to my case study from earlier, I've explained the bare bones of what did happen. It was presumed that the invoice would be coming from Bethan at pollux.com, and as I explained earlier, the fraudster instead sent the relevant invoice. Now, depending on the precise facts, the case for ostensible agency on the part of the fraudster might be more or less strong. So just by way of example, if Arno, when he had introduced Bethan to Catherine and Sirius, said that Sirius should follow instructions that are received from this email address, there is a very active, direct action being taken there on the part of the seller to say that whoever is operating this email address does have authority to give payment instructions. By contrast, you could see that if the facts are changed, the ostensible agency argument might be weaker. So if this was not a corporate situation at all, but instead we're dealing with essentially a sole trader type arrangement where actually Pollux is simply a trading name for Arno, then in that case, there would only be one person. There would only be Arno who was sending any emails on behalf of the company, and therefore the case to say that somebody else might have ostensible authority seems that much weaker. And reading between the lines, that is a point which was live in the J. Brazil Road, the county court case that I referred to earlier. So this is a nuanced analysis. It is always going to be fact dependent, but it is an alternative way of trying to strike the right balance between the interests of the buyer and the seller. The other option being the duty to procure that I mentioned earlier. So if the ostensible authority argument is to be advanced, clearly getting over the line of establishing essentially a prima facie authority is the main step to take. But that is not the end of the analysis. It's also relevant to consider how the instructions might be perceived from the perspective of Sirius, the buyer. If the buyer ought to have been put on inquiry by the fraudulent instructions, then the buyer cannot rely on the ostensible authority without doing something more to essentially verify their payment instructions that they received. So the question is then, what should be done to verify payment instructions. Now, the gold standard is always going to be that the buyer and the seller should have a face-to-face meeting. If you are meeting in person with someone who you know and they confirm the relevant instructions, then you can have an almost absolute certainty that what you are being told is correct. And it's certainly going to be binding on the relevant company. But it's obviously going to be commercially unworkable to have person-to-person meetings for all payment instructions in the business. As we will all be well aware from the sorts of arbitrations that we do see, parties engage in business across borders, across time zones. It may not be practicable for meetings to take place in person, and it may even be the case that companies are contracting with one another without two people ever meeting in person. It might be that the only contact has ever taken place online or through some other virtual means. So that would suggest that perhaps the next best thing to a face-to-face meeting is to have a Zoom meeting, such as we are having today, or perhaps something as simple as a telephone call. Now, this is where the advent of AI starts to come into the picture in this particular sort of fraud that we're discussing here. What I've got on this slide are two particular news items that caught my attention in recent months. On the left, there's a story that you may well be familiar with, not least it had a very strong Hong Kong connection. In that case, a company employee working in an accounts function was invited over email to join an internal video call. And also in attendance on that call were a number of employees from the company, including some senior officers. Now, during the course of that video call, the employee was instructed to make certain payments in the course of his employment and to do so from company funds. Now, this was perhaps unusual, but not so remarkable that it raised particular questions, because the employee in question did make the payments as instructed. However, it was only later on that the employee realized that this was all a very sophisticated fraud. What had happened is that certain fraudsters had themselves been responsible for setting up the video call and for providing the payment instructions to the employee in the course of that video call. What the fraudsters had done is they'd used generative AI software to produce likenesses of senior officers within the company. And those likenesses included both how they appeared on the video call, but also how they sounded. It made reproductions of their voices. So using these generative AI tools, the fraudsters were able to create a persuasive appearance on an online call that caused the employee to make a particular payment. And what is somewhat scary about this particular situation is that fraudsters were able to do this because there were existing videos and recordings online of the relevant senior officers of the company that the fraudster was able to use as essentially the training data for the generative AI engine to then produce these clearly very persuasive payment instructions on what appeared to be a live video call. So that's the story on the left. On the right, there's another story, perhaps a little bit less dramatic, but this is one where a Polish entrepreneur had used ChatGPT to create a fake copy of a Polish passport for himself. And the forgery, as we can see on the screen, looks genuine. There's no obvious error in it. And the individual concerned suggested that it would pass most image-based KYC checks. So these are two quite concerning situations to be faced with. The question is then how they mesh in with the topic that I've been discussing so far. And my answer is that this all raises serious doubts as to how we can be sure about our verification procedures. So returning to artificial intelligence, if Catherine wanted to verify the payment instructions that Sirius had received, she could seek to have a short Teams call or Zoom call with Arno. However, the example we just saw of the Hong Kong case, the company was called HKIArb, showed us that a Teams call is far from a fail-safe verification solution. It would be relatively straightforward for the fraudster to use generative AI to produce a short video appearing to show that Arno confirmed the fraudulent bank details. All that the fraudster would need was sufficient existing footage of Arno in some other context, and they would be able to use that to produce the potentially very persuasive video that would then be deployed on the Teams call. So that's the video call. I also mentioned the possibility of a phone call. Now, that in some ways is even worse. It's less secure because it would be easier to generate a compelling audio feed than a compelling audio feed that matches with a video. So what I'd say that these two particular instances show us is that there is a rapid advancement in what technology can do in terms of undermining the verification processes that just a couple of years ago would have seemed to us to be perfectly safe. What AI currently is limited by is the degree to which it can operate independently, or indeed its processing ability. So my understanding of the HKIArb situation is that the Teams call was essentially all pre-generated and videos were being played to the employee. There was not a sort of live reaction to what the employee was doing. It was just a well-planned fraud. So at the moment, the solution to my verification problem would be perhaps an unannounced phone call where the fraudsters wouldn't have enough time to prep a series of pre-rendered audios to provide the reassurance that Catherine might seek. However, this is all premised on the limitations of technology now, or perhaps even technology of a few months ago, because this brings me to the advent of agentic artificial intelligence. So far, I've been talking about generative AI, which relies on being fed a set of data points, and then from those data points, it pulls common constituent elements together and produces new data points consistent with the training data. So Gen AI could be used to produce a video of Arno based on being fed previous videos of Arno. The limitation on generative AI is that it all relies on the user, which is here the fraudster, to input into the software what the output should look like. So in my verification idea of a Teams call, the fraudster would have to input into the AI what Arno should say in the course of this video call. It would all have to be pre-programmed, pre-arranged, with then those essentially pre-generated videos being played to Catherine. That's why the unannounced telephone call could be quite effective. However, this then brings in the next step in the AI revolution, which is agentic AI. This is the next step on from Gen AI, because agentic AI has a greater ability to understand or process the context of its instructions and learn from interactions. It has more advanced problem-solving skills, and as such, can be given a more general objective and a set of capabilities, with the AI system then being one which will determine how to deploy its capabilities in order to best achieve the objective. So I'll explain what I mean by that in a bit more detail, but in short, the distinction is between Gen AI as a reactive model. It reacts to a user prompt, whereas agentic AI is proactive. It will take steps on its own initiative to achieve a particular goal. So considering our verification context between that Catherine is seeking to verify her payment instructions, an agentic AI version of Arno could be instructed to engage in a Teams call with Catherine and meet whatever concerns that she raises. In that sense, the agentic AI would be able to process questions that are being received from Catherine identify what might reassure her, and then use generative AI to produce a video live to play back and assuage the concerns that are being raised live. In that way, you're going to have a much more natural seeming representation of Arno, which is much more likely to pass any sort of verification assessment that Catherine is trying to make. The only limitation on this sort of technology at the moment is really processing power. I would suggest it is reasonable to expect that what I'm describing here as essentially an AI model conducting a Teams meeting on its own initiative without input is really not all that far away into the future. It's a slightly concerning thought, and just trying to bring matters to a bit of a close, I've got 3 questions which I've pulled together to try and draw to a close some of the themes that I've been talking about. So the first question is perhaps the most directly answering the title of my talk. And the question is it always the case that the paying party must pay the price again? And for the reasons I've given, I would suggest not. It may well be that the starting point is that the debt remains to be satisfied, but there are avenues available to argue either that it has been satisfied through perhaps an agency type analysis, or alternatively that there is a counterclaim that the buyer might have available as against the creditor for the same amount of the debt. And that's going to be based on the duty to secure, as I described earlier. It should be the case, I would suggest, that the answer to who bears the loss in these sorts of frauds is not going to be an absolute answer that in all cases the buyer must pay again, or in all cases it's the seller who is going to be responsible. It instinctively, commercially, it feels as if there should be room for an assessment as to where fault should lie and therefore where loss should lie. And the sorts of arguments I was explaining in terms of agency or duty to secure allow for that slightly more nuanced assessment, rather than therefore just be a hard rule that would apply in all scenarios. That's the first question. The second question is then, as artificial intelligence advances, how can we verify information that we receive over email? And for the reasons I was just explaining at the end when I was dealing with agentic AI, the answer is going to be it's going to be very difficult to reliably verify information. It may be that AI advances are such that pretty much any verification method is going to be capable of defeat by a determined fraudster. So that leads me to question whether email is still appropriate at all in business. And I would almost take a slightly extreme approach of saying, no, it's not appropriate, at least in this sort of context, to be sending payment instructions in a PDF file sent over email. It's a very insecure way of sending very important information. It can be easily intercepted, and certainly the number of cases I've seen with these sorts of issues being raised, it's something that is frequently intercepted, and there should be a much more sophisticated way of communicating with one another that isn't going to be so susceptible to this sort of fraud. And the third and final question is one that I pose more for you to go away and think about, because it's a much bigger picture question and not one that I have an answer to at the moment. And that is whether advances in particularly agentic AI technology mean that we need to revisit our conceptions of legal personhood and agency. So at the moment, AI cannot be treated as a legal person. The actor behind the AI needs to be identified. And there are cases in England and in Singapore, particularly in Singapore, about B2C2 and Coin, which was automatic pre-programmed trading, where the courts have tried to engage with the question of whose knowledge is to be essentially understood when it is technology which is making what appear to be autonomous decisions. But as AI becomes more sophisticated, as agentic AI becomes more capable and less able to be analyzed in terms of what its thinking process is, it becomes increasingly difficult to say that the knowledge or the views of the fraudster or the person who created the AI tool should be said to be the knowledge of the AI itself, which is taking these independent actions. So in a slightly futuristic sense, we almost have to ask ourselves, at what stage do we recognize that AI should be seen as its own legal person, rather than trying to identify what remote legal person might be standing behind the AI tool itself? So with that big picture question finished with, to which I'm afraid I don't have an immediate answer, all that remains is for me to thank you very much for your attention, and once again for bearing with me for this slightly delayed start. If you have any comments or questions on what I've said, I'd be very happy to hear them. And particularly, I'd be interested if you've come across the issue that I was describing of the compromised email account being used to send payment instructions, and how that particular situation was resolved. But otherwise, as I say, thank you very much for your attention. I'm just looking on the chat function and the Q&A function. If anybody does have any questions, please do let me know. Otherwise, I just one very brief observation, which in the interest of time I didn't want to go into, but on the point I ended on about at what stage should we be thinking about AI as something more than just a tool that people are using, but instead thinking about it as being its own thing, its own legal person. It in one sense is very much against legal orthodoxy, identifying essentially a machine as being a legal person. But we are used to having companies as legal persons, and that's been around for hundreds of years. Now, that was defensible in the sense of it's essentially a decision made in favor of commerce and allowing people to act through a company. But ultimately, we always knew who the person was we were dealing with. But an observation that was made to me recently by a client of mine is we're now very used to contracting with companies and dealing with companies without actually having any human intermediary. So if I was to go and make an online purchase today at an online retailer, it might very well be that my order is received, processed, accepted, all without any human intervention on the side of the retailer. And it might even then be that an item is allocated to my order, a replacement is ordered in from their supplier, and a delivery driver booked to deliver the item to me at home. Again, all without any human intermediary. So in that context, we have essentially a machine which is acting for the company. The company is only acting through the pre-arranged set of instructions. So in that case, it's not a hugely greater step to say, well, if it's an AI and the AI is acting in some independent way, perhaps they should have some sort of legal personhood. That's just one half-formed observation, which it did just strike me as something that we gradually become used to. And then suddenly it does seem as if that there may come a tipping point where we have to change or challenge our previous assumptions. But otherwise, there haven't been any other questions posed in the Q&A box. If anyone does have a last minute question, please do raise it now. Otherwise, I'll say thank you very much for your time today. I think that seems to be it. So thank you for not putting me on the spot with anything too difficult. And I hope you all have a very pleasant evening and that we get a chance to speak again. With that, I think I'll bring the webinar to a close. So thank you very much, everybody. Oh, just in time, sorry, a question has come in. Yes, if the agentic AI has legal personhood, who should bear the liability? The software company that developed the agentic AI or otherwise? So I think this is going to the difference between how we try and change our way of thinking. At the moment, if AI is responsible for some sort of harm, we do have to try and look to, well, who is the person standing behind the AI? Who is the person who is really responsible? So that's what the B2C2 and coin decision in Singapore was about. And in that case, they said that this virtual trading platform, which had made an error in assessing essentially whose knowledge is to be attributed to the platform, they had to look back and say, well, who was coding the platform? What would their knowledge, what would their opinion have been? And we're going to essentially give that or say that that knowledge is the knowledge that is that of the trading program. So at the moment, we would be saying, yes, if an AI tool does something, we would either be looking at the developer of the AI tool, or perhaps more likely the person who has given the agentic AI the objective, the initial instructions, and they are essentially responsible. Now, that's, I suppose, what would be the current view on a legal orthodox view as to who is a legal person. But if we were to say that actually agentic AI has reached a level of sophistication that agentic AI should be the legal person, it is agentic AI who would bear the liability. And what that means is that we have much greater ramifications suddenly for broader issues such as, well, an AI engine doesn't have any asset, it can't be enforced against. Therefore, AIs all need to have their own insurance, or maybe there does need to be some sort of way of essentially establishing vicarious liability on behalf of the system, putting that liability onto somebody else. These are all the sorts of questions that we will have to grapple with if we were to recognize AI as having legal personhood. But it's such a major step, I think, that we would have to have essentially legislation dealing with the personhood aspect, and therefore the sort of issues about, well, how would liability be established, who would pay, those sorts of questions are all going to have to be dealt with through legislation. So hopefully that answers the question there about personhood. One last chance. I'll give it 30 seconds for anybody else who might have a question. On that footing then, once again, thank you very much, everybody, and I will bring the webinar to a close. Goodbye for now.